Ms Connolly.
My Lord, as
I should confirm, sorry to interrupt you. Can I just confirm that I have seen and read the Children's Commissioner's letter of October 2019.
Thank you, my Lord. Thank you, my Lord. Before at lunchtime, I said I would be moving on to Chapter 3. My Lord, in my respectful submission, the most important evidence to address terms of reference 8 is found in the voices of the patients and the families. My Lord, I referred earlier to Mrs Mackay's comments on communication, and in the same statement that she provided in September 2016, she referred to the emotional, physical, and the other impacts that her daughter and the family had suffered. In that statement, she says it's very difficult to detail the impact on Ailey. Her life has forever been altered. She has to work harder for everything she wants and will forever face barriers. She has had to learn to accept the far greater changes in her life, becoming a wheelchair user, being diagnosed with epilepsy, to name but a few. Her physical changes are evident, but the severe psychological effects caused by these debilitating infections run far deeper than her visible scars, more so than would have been the consequence of her cancer diagnosis. Ailey chooses not to revisit her dark days, as it is a chapter of her life that she finds too traumatic. She prefers to concentrate on her recovery, moving forward with her life and her plans for the future. Our family life has been impacted and changed forever. The shockwaves permeating from this have wreaked devastation on us all and will reverberate for many, many years to come. We have been left in a state of stress, mistrust, disbelief, fear, worry, and with an enormous sense of guilt. Guilty for taking her to the Royal Hospital for Children in the first place for treatment of her acute lymphoblastic leukemia. A place that has become the vessel for the countless flaws, failings, consequences, and misplaced actions. A place where she should have been made better. A place where she was meant to be safe. A place that has left her, us and others, let down. I have accepted the baton on her behalf and aim through the Scottish Hospital Inquiry to seek justice, accountability and clarity. Listening to the evidence of the inquiry, the missed opportunities, the complete disregard, the countless flaws and failings, the monumental deficiencies, the negative culture, the mistrust and misgivings, the negativity and toxicity feels like physical blows raining down on me. Our family will never recover from this, and in our lifetime, we will never experience anything as traumatic again. But what we must all never lose sight of is the reason why we are all here doing what we are doing. The issue that is far bigger than all of us, the victims at the core of it all, the children, our daughter Ailey. In this fight, there are no winners, only victims seeking the truth. My Lord, Professor Cuddihy has provided the following additional statement in January 2026. And this statement, unlike the one that was included within the bundles in September 2024, September 2025, rather, my Lord, reflect on the impact of Molly's death within the context of the inquiry. Professor Cuddihy says, Molly first appeared before this inquiry in 2021, then aged 19, when she bravely provided written and oral testimony about her fight against metastatic Ewing sarcoma at the Royal Hospital for Children. In that evidence, she described repeated infections from unsafe wards, ventilation failures, water risks, and a lack of coordinated child-centred care under QEUH. Molly said plainly, "I got infections repeatedly. The wards weren't safe. They kept moving me around, but nothing changed." Those words expose not just clinical shortcomings, but systemic ones. Absent escalation, minimised risks, and families left feeling gaslit rather than supported. Since that time, tragedy has struck. Molly died at the age of 23 on the 26th of August 2025 at the Queen Elizabeth University Hospital, and her death is now the subject of an active criminal investigation. This inquiry therefore sits at a pivotal moment. Will it issue recommendations that, in line with its remit to learn lessons from the planning, design, construction, commissioning and maintenance of these hospitals, make similar failures in the future and consequent criminal investigations unthinkable? Or will Scotland be left with more reports gathering dust on shelves? Molly's legacy calls for the former, enforceable governance that honours her voice and protects every child by ensuring that future NHS infrastructure provides a safe, effective, person-centred environment for care. Molly's evidence revealed breaches of the blueprint for good governance at every level. The blueprint demands good and active governance in which boards and senior management rigorously pursue risk minimisation, escalate life-critical threats such as hospital water systems and ventilation, and ensure decisions prioritise patient safety over operational pressures in the design, commissioning and operation of major hospital facilities. Yet in the period Molly described, wards were closed reactively, not proactively. Infections recurred despite clear warnings. And there was no visible senior oversight of the environmental and infrastructure risks now at the heart of this inquiry. Corporate risk registers omitted these problems until inquiries forced their disclosure. Molly's case shows diffused responsibility translated into no responsibility. The statutory duty of candour, which should help ensure that patients and families are given clear information and meaningful involvement in decisions about their care, did not operate as intended. Families in similar situations to our own were not met with openness and apology, but with dismissal, blamed for complexity, while the evidential picture mounted. In paediatric oncology and palliative care, where children endure prolonged vulnerability, that culture is indefensible and directly relevant to the inquiry's focus on communication with patients and families. My Lord, I can provide a copy of that statement to your Lordship.
Yes.
My Lord, Lisa Mackay, Ailey Mackay's mother, gave a further statement in December 2025, and that is included in our written submissions. She said in that, "Finally, we have reached the conclusion of the oral evidence heard by the Scottish Hospitals Inquiry in relation to the Queen Elizabeth and RHC. This is a milestone in this inquiry, which was originally announced way back in September 2019. We now stand at a crossroads reflecting on the evidence heard and admissions learnt. The fundamental question, what happened, remains the same, and the hope is that with the inquiry and the passing of time, this question will finally be answered. Getting it right for every child is Scotland's long-standing national commitment to provide all children, young people and their families with the right support at the right time. It is both an approach and framework used by services across Scotland to improve and uphold the well-being of children and their families. a commitment adopted and implemented by Ailey every day of her working life within an educational setting for the children in her care. Can the same be said for her and the countless other children and young people who were patients? Did GGC get it right for every child? The Queen Elizabeth University Hospital and Royal Hospital for Children, Glasgow, was described as a state-of-the-art acute hospital, integrating adult and children's services, and that we never once questioned that. This flagship hospital is now permanently tainted with serious operational issues. Hearing and learning so much about ventilation and water systems prompts the memories to resurface of rooms too hot to bear and requiring a fan to be on 24 hours a day. The build-up of dried blood in mine and Ailey's noses due to the dry air. And in 2018, being told not to touch Ailey with the water. Are memories that are definitely abnormal. Moving forward and lessons learned are phrases widely considered overused cliches that have lost their impact due to frequent use. Their overuse highlights a lack of genuine change, as organisations often repeat the same mistakes despite learning lessons. We can only hope and pray that this will not be the case here. My Lord, Ailey Mackay also provided a statement that was part of our written submissions in December 2025, where she said, "I will need to carry this for the rest of my life, and where I want to go in the future has been made harder for me due to this whole situation and what I've been forced to live with. I am paying the price to basically live. I have so much to live for. I've had to battle through emotional and physical traumas to get here, and I am lucky I've survived, as I wasn't expected to. In this hospital, I should have been safe, but the building was killing me. My life is important and should never have been jeopardised the way it was. I was just a teenager whose life was turned upside down with a cancer diagnosis. It should never have got to the extent it did with the infections I contracted and how ill they made me. Myself and my family should never have had to go through this nightmare. For us and for me, this torment will never go away. Our lives have been changed forever, and we have to live with this horror for the rest of our lives. In hospital, we are asked, what matters to me? A question which relates to patient-centred care and what is important to each child. Now, when I think of this same question, my answer would be that the truth matters to me, and I think it is the least that I and my family deserve. My Lord, the last patient voice I wish to include in this chapter is that of Molly Cuddihy. As I said earlier, Molly prepared a statement to be considered as part of the hearing that was commencing on the 16th of September 2025. Sadly, Molly didn't survive for that hearing to take place. Your Lordship has a copy of this in the witness statements. Molly said, in October of 2021, I sat before the inquiry and gave evidence of my experience throughout my treatment. At that point, I was in recovery from my first relapse of my original cancer diagnosis, as well as the 2 separate incidences of Mycobacterium chelonae infection. I was 18 years old and truly believed that I had, at that point, suffered enough for a lifetime. However, I did not get that lucky, and over the past 4 years, my health has only further deteriorated, in no small part due to the intensive antibiotic treatment. I realised that my sarcoma was always a life-threatening condition, but there is a large difference between that and the life-limiting conditions that I now have to contend with. It's not just a difference of treatments and learning new medications and the like, but the sheer difference psychologically is immense. There is now no end in sight. There is no day to look forward to a cure, and I'm very likely to have a much more limited lifespan than the majority of my peers. I understand life isn't fair, that I had already been diagnosed with a rare aggressive cancer that is more than likely to be terminal the majority of the time. But surely at 22 years old, I should not be so resigned to such a future. I'm under the regular care of renal, gastrointestinal, oncology, endocrinology, fertility, and vascular specialists, with input often having to be given by pain teams and a whole host of others for my treatment. Many of my team are world-renowned in their own right, and every single one of them is incredible and are an exemplary show of our NHS. I'm so grateful to them all, and in no way have I found the medical side of my healthcare treatment to be lacking. The same cannot be said for the management of NHS GGC, and I feel the evidence that they have given only highlights that fact. Their utter contempt for the entire process has been clear, and the total disregard they've shown for the patients and their families has been startling. I mentioned the physical impact, but it feels like there's no thought given to the psychological torment that patients have been and continue to be subjected to with this. In my own case, it's been the most challenging aspect of my care that has only compounded by my participation in, and referring then to the public inquiry. Now, do not misunderstand me. I have never once, nor will I ever regret participating in the public inquiry, but it continues to have an effect on my daily life and mental health, such that I've had to seek consistent help over this period. I've had to watch members of the management sit and not only contradict the immense amount of evidence to the contrary, but their very own written statements. They haven't even had the decency to check beforehand to match facts. It has never been any one individual's fault, and nothing has ever been done with ill intent. Of that, I'm sure. However, when faults began to show, when they were asked for information, when they were simply asked why, their actions from that point on were done with the knowledge of what was wrong. But of course, in some opinions, we were cancer patients anyway, weren't we? It's all right for us to get sick. It was going to happen anyway. Why not just write us off when we get the initial diagnosis, if that is your thinking? If that is your attitude, for that I'll never be able to forgive. This past year, I was so incredibly fortunate to receive a kidney donated to me from my older brother, Dara. I cannot quite articulate how much I love and am grateful to him for that, for giving me a little of my life back. But it should never have had to be done. That risk should never have had to be taken. I should not have been terrified that not only was I risking myself staying in Ward 4C, where whilst their care has been nothing short of exemplary, I knew fine well, given the evidence on Ward 4B, that the ventilation alone was not safe. I was also risking my big brother, my favourite person, when he was already giving up so much for me. It's not just hospital stays, though. It's having showers. It's staying on edge to make sure all my medications are always right. It's trying to simply sleep. It all terrifies me and is totally illogical, and in my opinion, frankly ridiculous, because it's not exactly like I can avoid them, can I? Like I said before, the hospitals are a huge part of my life. The impact of it all has been so profound that it's even the little things that have changed, the big life decisions, that have had to be made or have been completely taken away from me is remarkable. My priorities have entirely changed, and the things I have been totally desensitised to genuinely frighten me. I am 22 years old and I've totally lost count of the amount of times I've almost died. Even accepted it as imminent at a few points. Like I said before, how is any of that fair? I do, however, want to note that I am incredibly grateful to the professionalism, respect, and genuine kindness that the inquiry team have shown throughout this process. I also want to note how delighted I am that we've progressed to the point of having a safe environment for the children of the Oncology Hemato-Oncology Department at the RHC. After working with the Glasgow Children's Hospital charity, I've been lucky enough to make a fair few visits to the Schiehallion and cannot emphasise the sheer delight and relief I feel whenever I see the children back where they belong, as safe and as happy as they can be whilst they go through their already tumultuous journey. My Lord, in conclusion, on behalf of the Cudahy and Mackay families, there are 3 additional, precise and actionable recommendations that we present for your consideration. These are expressly rooted in the Blueprint for Good Governance and Health. The duty of candour, and this inquiry's evidence and terms of reference. And my Lord, to provide context, the reason for these and why they're being presented to your Lordship now is not unrelated to the submission of others, particularly other patients and families, that it's important that this inquiry and the report that it will produce does not become part of a library collection, but there is monitoring and assessment of both your Lordship's recommendations, but also, and potentially could be done an earlier point, there's also an assessment or an audit of the extent to which the Blueprint for Good Governance and Health is evident across Scotland's health boards and hospitals. And in light of that, my Lord, 3 things are recommended. The first of which we've called blueprint audits. These would be mandatory independent audits of all boards on hospital infrastructure risks, to certify senior oversight and that should be accompanied by parliamentary reporting with ministerial enforcement. My Lord, the second recommendation is family pathways. And by this, we intend independent duty of candour pathways for deaths or serious harm that arises from infrastructure failings. And that these should include neutral reviews and national monitoring of communication practices. And the third and final one, my Lord.
Sorry, just give me the end of that one. Family pathways, independent duty of candour pathways for death and serious harm resulting from infrastructure failings. Now, how does it conclude?
Ensuring neutral reviews and national monitoring of communication practices.
Do you want me to ask a question about that, or do you want to?
I'm content for you to ask a question now, my Lord. Thank you.
Could you just tease out the concept of family pathways and identify at what point they should begin to be implemented?
Yes, my Lord. My understanding of the how this might operate is that we have obviously the duty of candour, but in the context where children and families are impacted by death or serious harm arising from infrastructure failings, this is a suggestion that there is a clearly defined family pathway that would be relied upon, implemented in those circumstances, and that pathway, the duty of candour pathway would be independent, so it wouldn't be something that would be reliant upon the management, for example, of the hospital where the incident happened to deliver. It's about a neutral review and national monitoring of communication. In essence, my Lord, what it's seeking to achieve is that both the duty of candour is being honoured within the healthcare setting and that there's effective communication practices in place. And it ties back, my Lord, to the aspect of the terms of reference of the inquiry in terms of communication with patients and families.
And would it be triggered by any adverse outcome or an adverse outcome that had been identified? It would have to be by the hospital authority as environmentally linked.
My Lord, I haven't thought of that in that level of detail. However, I don't think it could operate in that way if it was to be, it couldn't be only triggered by the hospital identifying an environmental issue. This is about really improving communication, both, and by communication, I don't mean just talking, I mean listening as well, by hospital management bodies to patients and families. And that's why it would be important for there to be a neutral element that's neither of these parties, that would require to input if there was a negation that there was an infrastructure problem, there would have to be if there's a conflict over whether there is that infrastructure failing and that's led to the harm or the death.
Mm.
In circumstances where that would be, if that's accepted by all parties, such an investigation wouldn't be required.
Right.
Thank you, my lord. And the final and third, my lord, is the implementation of national paediatric safety standards and hubs for paediatric oncology and palliative care.
Yes.
My lord, on behalf of those that I represent.
Again, with apologies for interrupting. So that third recommendation would be to add to the existing standards, which admittedly are stated in a fairly high level, particular standards in relation to paediatric oncology cases.
Yes, my lord.
Right. Sorry, I interrupted.
Not at all, my lord, thank you. My lord, on behalf of those that I represent, we hope that all of our submissions to date and recommendations will be of some assistance to your lordship in reaching your determination of the terms of reference. Implementation of our recommendations will not only honour Molly's memory and Ailey's ongoing journey, but hopefully will guard against recurrence of such harm and should catalyse genuine reform and restore public trust in NHS GGC services. My lord, if I can be of any further assistance to you.
No, you have been of considerable assistance. Thank you very much.
Thank you, my lord, I'm obliged.
Mr. Love. No, Mr. Love, you represent a substantial group.
I do indeed, my lord, yes.
Both patients and family members.
Yes, that's correct. Along with my learned friend, Mr. Thornley, somewhat distant, we represent and appear on behalf of the patients and families affected by their treatment at the Queen Elizabeth University Hospital and the Royal Hospital for Children in Glasgow. And thank you, my lord, for this opportunity to present this oral closing submission on their behalf. Your lordship has already observed that the public gallery is slightly fuller today than it has been. And I'm very grateful to and would like to thank the inquiry team for the steps they've taken and the measures that they've put in place to accommodate some of those on whose behalf I appear today.
Well, I acknowledge there's a limited amount of space that we've been able to offer.
The coffee has been appreciated, my lord. In terms, before I carry on, as your lordship had the opportunity of reviewing the collage or montage of photographs that appeared in the Scottish media today.
It's, for example, on the STV news website, I think.
Yes, it's the same collage, I think, as was submitted along with the closing statement for those I represent last December. Mm-hmm. But your lordship has seen that.
I have seen it and I've taken time to look at it.
Okay, thank you. I've listened, and I should say this at the outset, very carefully to everything that Miss Connolly has said. And I would associate myself with everything that she has said, including the observations that she makes towards the end of her submission about recommendations. What she says resonates to a remarkable extent with the experiences of those that I'm appearing on behalf of today. And there is nothing in what she said or in what she's presented that I take any issue with.
There are only certain things I can control. Mr. Love, I hope you're not going to be distracted.
I will not be. Thank you, Lord. It has in the past been stated that this inquiry is to a significant extent about patients and families. I had a discussion with Mr. McIntosh fairly recently where he asked me the question, why should that be so? And I would suggest, if I might, the following explanation. The inquiry, as its website states, came about as a result of public concern over issues arising in relation to the built environment at the QEUH and RHC and its potential impact, including infections, on patients and others. This concern had been reflected in widespread media coverage in relation to issues raised by patients and their families. Debates and questions to the Cabinet Secretary in the Scottish Parliament, and a number of other investigations. The inquiry's scope, its terms of reference, was developed with input from patients and families, and specifically aims to address the impact on patient safety and well-being ensuring their rights, in particular, to be involved with patient safety and well-being, ensuring their rights to be informed and to participate in their care were respected. From the start, this inquiry prioritised hearing evidence from affected patients and families about the physical, emotional, and practical effects of these issues on their lives, their lived experiences. Patients and families shared stories of children and adults dying as a result of infections and receiving potentially inappropriate prophylactic treatments because of the prevailing hospital conditions. Their evidence demonstrated or illustrated how technical failures might lead to devastating personal tragedy. One key theme in this inquiry has been how GGC's failure to provide timely, accurate, and full information to patients and families went to erode trust and made them feel unheard. For the patients and families we represent, this inquiry is crucial. First, for their understanding of who was responsible for decisions that led to harm. And secondly, ensuring that such failures in design, building, maintenance, treatment, communication, and candor never happen again. This is crucial in my submission to the protection of future patients and families. It is not unreasonable in these circumstances, my Lord, to suggest that a very significant aspect of this inquiry is to deal with the experiences of patients and their families to date, and to look to the protection of future patients and families, not just under the GGC umbrella, but nationally. And that in those circumstances, I submit it as fair to suggest that a significant aspect of this inquiry relates to patients and families. This inquiry has heard about the provision of safe, effective, patient or person-centred healthcare. And I'd like to explore what is meant by that. Ms. Conley has already provided your Lordship with some submissions in a paediatric connection. I would point your Lordship to the fact that hospital patients in Scotland have a comprehensive set of rights. Primarily enshrined in the Patient Rights Scotland Act 2011 and summarised in the Charter of Patient Rights, take this slowly, the Charter of Patient Rights and Responsibilities Essentially, what the Charter seeks to do is to provide a careful analysis of what the Act requires. But having considered both, sorry, Lord, yes.
Look for your assistance on a matter of detail.
Yes.
The reference to the Charter, the basis for that is in the Patient Safety Commissioner for Scotland Act 2023, or have I got that wrong?
It is. But I think the current, no, it can't be, because the current iteration is dated June 2022.
Therefore, I must be wrong.
So, yes, my understanding of the Charter is that effectively it provides a summary of what patients are entitled to expect, given the provisions of the 2011 Act. I could check the genesis of that and provide some further information to Your Lordship through the inquiry team.
I might have got that wrong.
What I'm proposing to do and what I say now is what I have to say about what safe, effective, patient or person-centred healthcare is based on my reading of the statute and the Charter. In my submission, my Lord, patient-centred healthcare should require the patient to be at the heart of their own care. And if I might expand upon that, that means treating them along with their family as an equal partner. And by that, I mean making decisions with them, not just for them. And providing clear, understandable information about conditions. And by that, I mean their conditions and also the conditions in which they're being treated. That should encompass the risks and the options, looking towards obtaining meaningful and appropriate informed consent. Your Lordship has heard evidence about that in this inquiry. And my submission to Your Lordship is that that requires their values their needs and their preferences for a personalised, coordinated and empowering experience to be respected. And that being so, it moves beyond just clinical outcomes to consider the patient's emotional and social well-being, involving them and their families and carers in the planning and management of their care. Echoing what Ms. Connolly said, showing them respect, affording them dignity, telling them the truth. Affording them the right to provide feedback, comments, concerns, or complaints, with support being made available to them in that regard. participation in their care journey. Why does that matter? From what I've been told, if I might take this slightly more quickly, my lord, what I've been told by patients and family members, it would allow them to become more engaged and active in managing their health, perhaps even leading to improved results. It would see a move away from what some of those I represent have called outdated, a one-size-fits-all approach, turning to a set of circumstances that seek to fit individual needs. That would go some way to addressing the feelings of powerlessness described by some, increase satisfaction, and improve the experience of what is frequently the toughest of times in that patient or family's life. That matters. It would matter to all of us and our families if we required hospital treatment. It's been interesting to review the evidence heard in Glasgow 1 for the purpose of presenting this submission today, and to see that there were so many plaudits and positives from patients and families about the excellence of the healthcare professionals engaged with their treatment and clinical care. Again, that resonates with what Your Lordship has heard from Ms. Connolly. The evidence that Your Lordship heard about lack of honesty, issues with candour and communication, was directed at the GGC management, board and managers. As was stated in the closing statement submitted at the end of Glasgow 1, it was felt that management did not keep patients and families informed about risks, about ongoing remedial works, or the causes of infections. And many felt they were kept in the dark, and that frontline staff were left to field questions about adequate support or information from management. Not a single witness identified a good example of communication by GGC managers on these issues. And that contrasted starkly with the generally exemplary communication from doctors and nurses about direct clinical care. Patient-centred healthcare puts the patient first. That's all I propose to say about safe, effective, patient or person-centred healthcare. I think that, based upon the Charter and the statute, is my analysis of what might be sought to be provided. There's also been discussion about what a safe healthcare facility might look like, and would agree with those who have suggested that there are many aspects to safety. And your Lordship's hired a positive and proactive culture where safety concerns are listened to, where incidents are investigated, and where lessons are learned to embed good practice. Competent and sufficient staff, safe systems and processes, including risk assessment and management, and tied with that, infection control and medicine management, including their safe prescribing, storage, and administration. Ultimately, in my submission, a safe hospital is one where the fundamental principle of first, do no harm is upheld through a robust, systemic approach to avoiding preventable harm.
Sorry, just can I take that again?
Certainly.
You refer to the principle of do no harm, the familiar.
Yes. And suggested to your Lordship that is a hospital where the fundamental principle of first do no harm is upheld through a robust, systemic approach to avoiding preventable harm.
Right, I think it was failed to get the word avoiding.
Yes, there has to be, perhaps I omitted to say it, but the system is important within that model. In any event, following that rather lengthy introduction, I would formally adopt the content of each of the closing statements already submitted on behalf of the patients and families. And with your Lordship's leave, I propose to make additional oral closing submissions under 6 chapters. That might sound ominous, but given what Ms. Connolly has said, I will seek to do what I can to foreshorten what I had intended to say.
You mustn't feel under any time pressure.
Yeah. But there are, I would not want to take up your Lordship's time with duplication with matters that I acknowledge and accede to in terms of what Ms. Connolly has said. Issues that I take nothing with, facts that I take no issue with. So the 6 chapters that I present to your Lordship are firstly, comments on GGC's closing statement for Glasgow 4 and the impact that that has had on those I represent. Secondly, what I intend to do is to read some extracts from the personal impact comments that have been received from patients and families in response to the GGC closing statement, which I understand your Lordship has a copy of. I think they've also been circulated around other representatives of core participants.
I do.
Thirdly, I propose to make some very brief observations about ventilation before, fourthly, going on to Scottish Government oversight. Fifth, I will look at the issue of accountability, including personal blame and responsibility and the importance of that. And finally, I will make some comment about the proposal made in our closing statement to the effect that your Lordship might wish to consider it appropriate to keep this inquiry open. So the first chapter is impact of the GGC closing statement. At the outset, the patients and families have asked me to communicate to your lordship that the conduct of GGC throughout these proceedings has left them with a profound sense of anger and feelings of betrayal. Their pain, they say, is not simply rooted in the suffering they have endured, it has been deepened and magnified by the shifting positions and evolving narratives adopted by GGC as this inquiry has unfolded. If I might say, it is my experience that these changes of approach have left patients and families questioning the integrity of those entrusted with their care, and that is to date. They feel that early denials and minimisations have given way only after fairly exhaustive evidence and public scrutiny. To what have appeared to them to be somewhat brief, grudging, and incomplete admissions of failures and individual responsibility, as presented in both the written closing statement and in what Mr. Gray KC said in his oral submissions earlier this week. This pattern of response, if I might call it that, has eroded trust. Instead of openness and candour, the patients and families consider they have been met with defensiveness, delayed acknowledgements, and an apparent reluctance to accept the scale of the failures at QEUH RHC. That said, they do ask that I publicly acknowledge and welcome the apologies that have now been offered by GGC, while making the observation that these are insufficient and come far too late for many families. Late apologies made only after public exposure and inquiry evidence cannot erase the distress, suffering, and in some cases, irreparable losses that have been experienced by some over the many years since the hospital opened. It's observed that changes have occurred on so many fronts, from denial to acceptance, coming more than 10 years after the hospital opened its door to patients. Rightly or wrongly, it appears to those I represent to be driven not by genuine remorse, but rather by the weight of evidence and public pressure. And this only deepens their sense of anger and feelings of injustice. And taking all on board that Mr. Gray said in his closing submission.
Excuse me.
Sorry, Lord. Yes, taking all on board that Mr. Gray said in his closing submission. Time will ultimately tell if the promises and undertakings that Professor Gardner gave in her evidence about a humble, patient-centred, proactive health board are more than just words.
Excuse me.
There are observations that I would make that really Miss Connolly has already made, and I think were touched upon by other representatives. This inquiry has been ongoing for over 4 years, at significant expense to the Scottish public purse, and only now, in its final throes, have GGC conceded many significant and impactful failings on their part. Had they done so sooner, much of what has transpired might have been avoided. As your Lordship knows, the patients and families that I represent have been using this hospital since 2015. And they've been astonished, in fact, angered to hear GGC now state openly that their flagship hospital was not ready to open when they took control of it from the contractors in 2015. GGC now say in their December closing statement that it is clear that the hospital was not in a state to be handed over when it was.
That is indeed what they say. I'm not sure if I recollect the evidential. I mean, they're in the best position to judge. I have to say, speaking frankly, as I would hope I would always do, I can't quite remember a strong evidential basis for that. There was the evidence from Mr. Parry about the challenges he met, and we do have the evidence about contractors still being on site.
It seems to be a reasonable inference to draw from the other concessions that have been made about the ventilation and water systems and culture, and all of these factors taken together, looking at the responsibility of senior board members, in particular in terms of their oversight of the project. It's not unreasonable to say, with the benefit of hindsight, this hospital, at the time it opened, was not fit for purpose. And of course, we're not looking at small or discrete sections of the hospital. Rather, we're talking about the water and ventilation systems, fundamental hospital systems. The ventilation system fundamental in a hospital where it required to be mechanically ventilated for the reasons that your Lordship has heard about in the evidence. And those systems, which your Lordship has heard evidence about, presented an increased risk to the health of patients being treated there. The patients and families have asked questions. Why did it take until December 2025 for GGC to publicly admit an increased rate of environmentally relevant bloodstream infections amongst paediatric hemato-oncology patients in the RHC during the period 2016 to 2020? Why have they only now admitted that a material proportion of those environmental infections were connected with the hospital's water system? Why have they only now admitted that the water system presented a risk to patients, including adults, and that there was a causal connection between some infections suffered by patients in the hospital environment, particularly the water system? In that regard, I've been asked to point out that the closing statement for GGC does not restrict the acknowledgement to risk to paediatric patients. And the risk is discussed in the context of all patients exposed to the hospital environment. And in that regard, I would refer you to GGC's closing statement at paragraphs 4.3, 4.4 and 5.3. The fact that it has taken a 4-year public inquiry for GGC to make those admissions is difficult to excuse. Other observations that have been made by those that I appear for today are that there has been no explanation from GGC as to why they have denied all responsibility for the mistakes, admitted mistakes, in the procurement, design and validation of the hospital before it was opened.
It would appear that they no longer deny, I think, what the expression is, failures relating to design and construction. Or am I wrong about that?
I haven't been able...
I understand that Mr. Gray accepts Counsel to the Inquiry's analysis, and I have assumed that there's an acceptance of the use that of language one sees as failure.
Where does that failure lie?
Am I wrong in this?
Where does that failure lie, though? I think that's the issue.
There is a lack of precision.
Yes.
But there seems to be an acceptance of failures which had consequences.
They do accept that there were failures on their part with the design, build, commissioning, validation and operation of the hospital. But what they have not done, in my submission, is specified exactly what those failures were and who was responsible for them.
That is
who is
true.
To blame?
That is true.
Their closing statement and their submission is, for what I can see, silent on that front. They do accept that multiple parts of the procurement process was fundamentally flawed. They admit there was a lack of appropriate in-house expertise. In the project team, they admit that there was insufficiently rigorous scrutiny of the decisions and actions of contractors. The individual who was put in charge of the project to design and build the new hospital had no experience at all of a construction project on anything like the scale he was faced with. This fundamental, in my submission, lack of experience and knowledge at the head of the project team and of the team itself ought to have been obvious to the executive board of GGC at the point the project board was being set up. And indeed, it should have become all the more apparent to them if they had exercised oversight as the project progressed, that there were issues. And given the lack of crucial expertise or any meaningful attempt to secure advice from someone who had that expertise, it is perhaps not surprising that there were multiple faults and failings with the hospital when it opened. And sticking with that point, the project team made multiple mistakes during the design phase that have so far cost many millions of pounds. And despite these clear and obvious mistakes, we have never heard any acknowledgement or admission or apology from any member of the project team throughout the evidential hearing in this inquiry. Nor, for that matter, my Lord, has there been any acknowledgement or admission or apology from anyone who was a member of the executive board of GGC, both prior to the opening of the hospital and thereafter down to the point of Professor Gardner's appointment in February 2025.
When you use the word executive board, could you just help me with what you're referring to?
Well, the chief executive and his board.
Well, it's not the chief executive's board. It's
the chair.
It's probably the chairman's board, insofar as it's any individuals. Are you referring to the health board, or are you referring to the executive directors of the board?
It's the health board, the executive, the members of that board, and the managers.
Right. So it's. I think I've got that.
Yes, thank you, Lord. GGC now says that it accepts that governance up to the point the building opened had weaknesses. That is, with respect, a gross understatement. The project team agreed with the contractors to have a ventilation system for the hospital, which not only did not meet the requirements of the prevailing Scottish Health Guidelines, SHTM 0301, but the system provided less than half the required levels in terms of air changes. They did this without, it appears, any assessment at all of the additional risks likely to be posed to patients in consequence. There is no evidence to that effect. And it's my submission that the public might be entitled to expect that such a crucial or critical decision would have been subjected to intense scrutiny and oversight by NHS GGC before it was agreed. It is clear in my submission on the evidence that that did not happen. The explanation given is for the fact that they did not know about this until the hospital opened was based on individual failures to advise. And we've yet to have an explanation as to why there was no proper scrutiny or oversight by GGC or its managers of the key decisions made by key individuals. In fact, what GGC explain in their closing statement is that it was due to extreme pressure caused by the evolving situation. That's at paragraph 6.15 of their statement. That, I submit, is simply not correct. But ultimately, that's a matter for your lordship. The head of estates admitted in his evidence that he failed to action the 2015 DMA Canyon report, and admitted in his evidence that he dropped the ball. In my submission, GGC ought to accept its failures and to apologise rather than trying to blame it on an evolving situation. Many more people dropped the ball.
One might observe in relation to that evidence that indicated a frankness and an acceptance of personal responsibility on the part of that one witness.
I looked at his evidence yesterday and he answered questions from Mr. Connell very carefully and agreed and accepted that with hindsight he dropped the ball in that. I looked to see if there was an apology for that, but I don't think he needed to in those circumstances. He was very clear that he did not do as he accepts he ought to have done.
Yes.
So GGC accepted the hospital from the contractors at a point when it had a water system that needed significant actions to ensure that the water did not pose a risk to patients. I don't intend to go beyond what Ms. Connolly has already submitted to your lordship in that regard. And it comprised a ventilation system that was way below the recommended level in Scottish Health technical memoranda for general wards, all the more so for the specialist wards catering for immunocompromised paediatric and adult patients. While Ward 2A is following substantial upgrades suitable for paediatric immunocompromised patients at the RHC, there is currently no SHTM 0301 compliant ward suitable for adult immunocompromised patients at the Queen Elizabeth Hospital. And I would also make the observation that while Ward 2A has been validated, I'm not aware of any evidence before this inquiry about validation of either general wards or specialist wards, such as Ward 4B, the BMT unit. Now, that was something that Mr. Gray KC raised in the course of his closing submission, said that it was his understanding that there had been validation.
Well, he'd be surprised if there had not been. And I think in the context, I hope I'm not misrepresenting him, he wasn't taking issue with the evidence that, as at 2015, nothing had been validated. But he would be very surprised if, where there has been remedial work, such as in 2A, that it has been validated, and he may very well be right about that.
But what I'm submitting to your lordship is that we have no evidence in this inquiry that beyond 2A, the ventilation system has been validated anywhere else in the hospital.
Certainly, there's no suggestion that. I'll take that back. I'll take that back. I think you're right about that. Yeah.
And I hear Mr. Gray saying that he would imagine that it has been done, but that's not the same as saying that it has been.
Indeed.
I simply point to the absence of evidence in that regard.
I hope this is not an unfair point. I mentioned paragraph 51 of a positioning paper 1 of GGC. It's just in the context of a ventilation and Ward 2A, what one sees, and in fairness, I didn't raise this with Mr. Gray. It's in the context of discussing the Innovated Design Solution Report of October 2018, which I raised with Ms. Connolly. What GGC in December of 2022, which is the date of the first positioning paper, in discussing that, so the context is October 2018, the GGC refer to evolving knowledge that the ventilation arrangements on the ward were not compliant with the standards set out in SHTM 0301. Do you have any comment on the concept of evolving knowledge in October 2018 that 2A did not comply?
It seems astounding that that could not have been identified at the point in time when the hospital opened. Given the specialist nature of that ward and the moving of the old Schahalian unit to its new premises, with the patient cohort likely to use that ward and to have their treatment facilitated and the safety safeguarded in that ward, it should have been known at the outset. The day the hospital opened its doors to that paediatric cohort, in my submission, GGC ought to have known whether or not the ventilation system on that ward was or was not suitable for the treatment and accommodation of those patients. And if they didn't know, they should have known. It ties in with the evidence about the move of the Beatson from its original home to 4B and what was found out when they moved. That there's one thing to look at the general wards within the hospital to make provisions in that regard, but to look at the specialist units which are being used to treat and accommodate immunocompromised and neutropenic patients, where it's known that the ventilation system and its requirements have to be high-end to protect them against the environment and the risk of infection. Not to know or to suggest that the knowledge about what the ventilation system provides is something that evolved over a period of years is astonishing. That concludes all that I have to say about the first chapter of my submissions. I now move on to the reactions of some core participants to the GGC closing statement. And as Ms. Connolly, I think, said in the course of her submission, perhaps the evidence of the patients and families is the strongest evidence that's available to challenge what GGC says about the extent to which relationships have been rebuilt. For the avoidance of doubt, the statements that have been produced to your lordship and the other co-participants merit the label of new. They're not extracts from statements previously tendered or evidence that's been submitted to the inquiry or alternatively contained within any of the closing statements previously tendered on behalf of the group that I represent. So these are new statements. So firstly, if I might read what Denise Gallagher has said. They are backtracking and only skimming over the issues after denying it all for years in a bid to protect their reputation. The risks all remain, and the submission is disrespectful to what the families have been put through. Kenneth Murdoch says, "We feel betrayed, lied to, and appalled by what has been allowed to happen. All the years of denial, and then December 2025, we get a total U-turn with the GGC submission. In our eyes, it's disgraceful. Our daughter was a ball of light, energy, and had a right to thrive and live. NHS GGC have entirely extinguished that light to protect their own reputation. Patients must always be kept at the centre of any key decisions, including by this inquiry." Beth Armstrong says, "We have been unable to grieve properly for our mum and remember her remarkable life. Instead, we have been subjected to 7 years of evasiveness, denial, and disrespect by the QEUH management and board, the very people who were supposed to protect us and put our safety first. Our grief has been extended, delayed, and turned into anger as we have listened to representatives of the NHS GGC board and QEUH management, including CEOs and CFOs, give evidence to this inquiry, refusing to admit their mistakes or take any accountability. We have listened to them blaming others and refusing to apologise for the terrible consequences of their actions. We have read the GGC closing statement, where they have had to admit, in part, to a link between the water and some infections. This has done nothing to restore our faith in the leadership of the QEUH or NHS GGC. As one of the families that was not included in this partial admission, it is yet another insult on top of many others." And her sister Sandy, "After all these years, this submission is just backtracking in an attempt to protect their reputation. In my evidence to the inquiry, I spoke about the SCII report. It should be, that's the Scottish Centre for Infections and Infectious Diseases report that was commissioned by NHS GGC. Everything that was ignored and dismissed and what happened to my mum. This is too little, too late. It adds insult to injury. For example, the HAD report. This does not give us hope with the current CEO or management structure. They are vague and being non-specific, taking no responsibility. It leads to further distrust and shows nothing has changed with their approach. Merely suing Multiplex is not taking responsibility for their feelings." David Campbell, "Nothing has changed. I've told GGC that the problems I've been identifying even today have been causing me mental health issues and concern for me and other families. I still feel I am ignored. The submissions are only words in a bid to minimise the reality. I am shocked that the submission is so short, given what they were facing and have admitted." Maureen Dines says, "I am concerned and worried that there is a desire to highlight how the mitigation measures are working, particularly after 2019. I would like to remind Lord Brodie that in 2012, 2 years after mitigation measures were put in place, my husband, Tony Dines, passed away. I was advised he contracted aspergillus, but there were no indications that it had come from the environment. One other infection he caught was stenotrophomonas. I've never been advised by NHS GGC of the stenotrophomonas infection that Tony contracted. I only found that out by looking myself at his medical records." Sharon Barclay notes, "I still cry when I go near the hospital, and this submission only confirms to me that GGC have mistreated everyone for years." Karen Stirrett, "We have been put through so much, and for NHS GGC to deny they concealed anything is laughable. All the way through we were told we were in a safe environment. Years of being told we were imagining it, that everything was safe and that our children were being treated with respect, and that NHS GGC would never put our children in danger. days spent sifting through papers, liaising with MPs, attending interviews, attending court, being in the media, all the while fighting a horrendous cancer battle with our poorly child. Still, they denied everything. There is no elation, there is no celebration that we have been proven correct, just a sheer anger and sadness that it should never have happened in the first place. Kimberly Darragh says, what they have said in their submission is eye-opening. Children with cancer must be protected from the environment, and NHS GGC had no right to gamble with their lives. I feel angry, not fleeting or irrational, but justified anger. Anger at a system that denied there was a problem for 6 years. Anger at the lies, the minimising, and the refusal to take responsibility until the final hour while my child paid the ultimate price. Charmaine Laycock and Alfie Rawson, the evidence in what NHS GGC now say confirms that we were right all along. The amount of money that has been wasted by the public purse has been huge. This could have been solved years ago with communication, honesty, and a hospital that was fit for purpose. Getting to the end of the inquiry, we are hoping for answers, for change. We are hoping that someone will be held accountable. We are mad that it took this long for the answers to come. We are angry at the money and time this has cost. We are angry that our lives have been put on hold for years to have a total U-turn in the last stretch. There's no winners here. We don't feel relieved or happy with any of what is going on. We are broken beyond belief. And then finally, Louise Slorence says the GGC closing submission is a work of fiction. Stating something in a document doesn't make it true. The idea that the whole QEUH, and in particular Ward 4B, is safe today is quite frankly ridiculous. The response leaves me with the feeling that I have failed in my aim to prevent what happened to my family happening to other families. And that concludes the second chapter of my submission. The third chapter is to deal with ventilation. As I said, there's a significant overlap with what Ms. Connolly said, so I have taken the time to omit from my submission certain aspects that I intended to comment upon. But ultimately, GGC provided a hospital where the air change rates were and remain significantly below the recommended levels identified in SHTM 0301 for most of the Queen Elizabeth University Hospital and Royal Hospital for Children. This deficiency has, on the evidence before this inquiry, the potential to increase the risk of harm to patients. Despite that fact, and the length of time GGC have been aware of this issue, they appear to have failed still to carry out a risk assessment of the ventilation system for the rooms and corridors in the vast majority of the hospital. I've made play in closing statements of the absence of evidence not being evidence of absence, but what we have not heard in this inquiry in my submission is about the extent to which the ventilation system and its consequences for patients, individual patients, has been risk assessed. As I've already said, we are not aware on the evidence to this inquiry about the extent beyond Ward 2A to which the ventilation system has been validated. It's accepted that the system doesn't conform to guidance. It's accepted that such non-compliance has the potential to increase infection. It is said that safety is not a binary issue and that other control measures can mitigate risk, and that's plainly correct. The expert evidence before this inquiry, as Ms. Connolly stated, did not identify an increase in infections attributed to the ventilation system. It appears that in those circumstances, GGC does not accept a direct causal link between the ventilation system and actual harm to patients, though they recognise that increased infection risk. Absence of evidence is not evidence of absence, and GGC accepts in its closing statement that there were failures in monitoring and in maintaining the air systems, including shortcomings in sampling and testing, particularly in the period following handover. They make those concessions at paragraphs 5.14, 6.15, 11.4 and 12.3 in their closing statement. In that regard, I think it would suffice for me, unless your Lordship wishes me to comment further, to simply adopt what is said in that regard at section 5 and paragraph 6.4 of the closing statement submitted on behalf of the patients and families in December last year. If I could move on now to chapter 4, which is the issue of Scottish Government oversight. And I suppose to make matters easier and to short circuit things a little, I would adopt what Mr. Connell said on Tuesday in this regard, and also the recommendations proposed by Counsel to the Inquiry at section 10.2 of their closing statement, and that's commencing at page 584. It's my submission that the evidence demonstrates that there was no meaningful scrutiny or oversight by the Scottish Government over the procurement, design and construction phase of the hospital. The lack of any proper oversight of a construction project of this scale, when the government are paying for the project from public funds, might be as an Scottish Government's responsibility in managing funds. What term of reference 5 states or requires this inquiry to do is to examine whether, based on the governance arrangements in place, national oversight and support of such large-scale infrastructure projects was adequate and effective, and whether there was effective communication between the organisations involved. The key phrase in my submission is national oversight and support, and whether that was adequate and effective. And that, ultimately, as all things are, a matter for your Lordship. But it seems reasonable to submit, on the evidence we have heard, that there was an absence of effective and adequate national oversight. Because if there had been, the catalogue of mistakes and errors that have been conceded may have been identified sooner. In their closing statement, the Scottish Government appears to me, in any event, to ignore the question of whether there was effective national oversight for this project. Ms Crawford, KC, made submissions about that yesterday, but it nevertheless seems to patients and families that many of the mistakes and problems that afflicted the project before the hospital opened might have been avoided or at least minimised, if not identified, had there been some level of meaningful oversight by the Scottish Government. I don't offer, I'm afraid, to your Lordship, any particular scheme by which that might occur. And to that extent, it is a high-level observation. But to largely rely on a health board to get on with the procurement, design, build and ultimate acceptance of one of the largest healthcare projects in Scotland merits more scrutiny than appears to have been provided.
I understand what you say. You're making a high-level submission, but further supervision would have required some method of intervention subsequent to approval of the full business case. Am I right?
Yes.
Yeah.
I think,
and you say there should have been something.
Something, yes. And looking at what is said by the Scottish Government in its closing statement, there's reliance placed on a document called the Blueprint for Good Governance in NHS Scotland, which sets out the 10 principles, apparently, for good governance that NHS boards are required to follow. And the Scottish Government submits that these principles provide a solid foundation for the adequate and effective oversight and support of large-scale infrastructure projects. They may well, but I submit there's no evidence from which this inquiry might conclude that these principles alone would have been likely to prevent the failures in procurement, design and build stages of the QEUH RHC project. And specifically, it fails to address the fact that the Scottish Government left the project, a project funded by a spend of £840 million of public money, largely in the hands of a health board that lacked the technical experience to implement and manage it. By adopting that approach, the Scottish Government perhaps lost the opportunity for some level of professional oversight, which might ultimately have prevented the mistakes, mismanagement and failures. The reason that I mention the technical expertise element is that that doesn't figure at all in the Blueprint for Good Governance.
But a well-governed organisation with no particular expertise, albeit one that may have responsibility for all sorts of things, can always hire that either in direct employees or in contracted consultants.
Absolutely, my lord, and I suppose I could expand upon what I've said to say that the fact that the health board itself did not have the personnel with the requisite expertise would not have prevented them from seeking that expertise elsewhere. But it may be that oversight at a national level by the government might have seen that that level of experience was available, if not internally, but certainly contracted in.
Would you accept that, I mean, you accept the point you're not putting forward a scheme, but if there was to be some scheme of national supervision, it's beginning to sound at quite a detailed level. I mean, for example, checking whether or not Curry and Brown are still employed.
Yes, I accept that, my lord. I'm not offering up any option, as it is complex. But I make that
proposal.
submission in any
Yes.
event in that proposal. That's all I have to say under that heading, and moving on to personal blame and responsibility. And we'd open by saying that we agree with GGC in their recent closing statement when they say that at paragraph 3.7, that it is critical that people have been held to account, and where criticism is due, it is right that it be made robustly. To date, no individual who was responsible for the serious failures and accepted mistakes, both before and after the hospital opened, appears on the evidence that we've heard to have been held to be accountable. It is my submission that where appropriate, and that's entirely a matter for your lordship's discretion, this inquiry ought to be holding those individuals who were responsible, those who contributed to failures and mistakes, those who were to blame, to account. And I say, sorry, Lord.
You use the word account. I mean, there's a limited amount that a report of an inquiry can do.
I fully accept that.
I mean, a report can name names and describe behaviours, but that's probably all it can do.
Yes, there's no teeth to do anything beyond that. And by, I suppose, is my loose use of language, for which your lordship has my apologies. I mean blame. Who is to blame? And I say that because during a public inquiry, it's more likely than not that criticisms are going to be made of individuals and organisations. That's more likely than not with a public inquiry. And as a result, what your lordship as chair can do is to make findings or conclusions based on those criticisms, the criticisms made of individuals. Alternatively, your lordship as chair might use the findings and conclusions to raise criticisms about individuals. Obviously, it is accepted that Section 2 of the Inquiries Act makes it plain that an inquiry has no role to determine any person's civil or criminal liability, but an inquiry panel is not to be inhibited in the discharge of its functions, this is subsection 2 of Section 2, by any likelihood of liability being inferred from facts that it determines or recommendations that it makes. And as your lordship will be aware, warning letters ensure that before being named and criticised in a report, individuals and organisations have to be given a fair opportunity to respond to any proposed criticisms.
I mean, I asked Mr. Gray about, I think the expression I used was attribution of responsibility. And I don't think he departed from what was set out at 3.7. But when we turn to the paragraph which might be seen to be pointing in a different direction, and I'm just wondering if I can find my note. Because there is a paragraph where he, or rather, GDC, yes, it's paragraph 7.1.
Yes,
It is submitted that personal or professional criticism should not be made of any of these individuals for how they reacted to the extreme pressure they were under. So I was trying to explore with Mr. Gray how he distinguished these two categories. Now, I may have failed to entirely take on board everything he said, but it appeared to me that he was distinguishing between persons who I picked up from him were responsible for the procurement and construction phase, and then those who may have not done terribly well in the situation of crisis, which he described, or I can't now remember
the extreme
phrase,
pressure that they were under by virtue of the prevailing circumstances,
yes,
very broadly, I think.
And if I picked up the distinction he was making, well, it's one thing to blame people at a sort of planning and stage, but if you're dealing with a very untoward situation, it is inappropriate to what we're talking about here is name names. Now, do you have any comment, or can you assist? Would you make a distinction, or what would your submission be?
My submission is that the purpose of a public inquiry is to look at what happened, to explore the facts, and to identify what happened, with a view to asking the question, why did it happen? And I think inherently or intrinsically involved with that is the question, who is to blame? And having followed through those two steps, to move on, to look at what can be done to prevent this happening again. There are many books and articles and documents produced by the Scottish Parliament's Information Centre, references to Jason Beer, KC, in relation to the issue of why have public inquiries and why is it important to name names and to name the people who are to be blamed. And I would draw your Lordship's attention, and I've provided, I think, 3 PDF documents, I think, through the inquiry team. There's the briefing by the Scottish Parliament Information Centre dated the 13th of May 2025, which looks at, among other things, the cost effectiveness of Scottish public inquiries. But at page 2 of that document, it provides a statement attributed to Jason Beer KC that answers the question, why are public inquiries held? And that's the basis upon which I make the submission to your Lordship about why public inquiries are held, to find out what happened and who's at fault. The briefing by SPICE, as it's headed, refers to the Institute for Government's 2017 report, which I think your Lordship should also have, headed How Public Inquiries Can Lead to Change.
Yes, I mean, I think we're on the same page, but just for those listening to us, you're drawing my attention to a document headed Finance and Public Administration Committee and the Scottish Public Inquiries. Now that, I take it, was an information paper issued prior to the Public Administration Committee's inquiry.
It is.
To sort of provide people with background information.
A backdrop, yes.
And you're referring me to what was said by Jason Beer, KC, who's a nationally recognised, well, he's the author of the leading textbook. And in turn, you're referring me to the Institute for Government's How Public Inquiries Can Lead to Change.
Yes,
right.
I am, Lord. And they may provide a bit of insight into why public inquiry should name people, and the extent to which inquiries uncover the truth in my submission is critical to whether they succeed in restoring public confidence in the institutions involved and to providing called victims and their families with some sense of having been heard. So affected parties and the public alike are keen to understand who is at fault. And inquiries can, and in my submission often do, highlight where failings have occurred, although, as I've said, they can't establish criminal or civil liability. And my submission to your lordship is that public confidence in bodies such as health boards and the government is often damaged by crises. In my submission, transparent identification of those involved or responsible can help to restore trust by demonstrating that the inquiry is thorough and hasn't shielded those who are demonstrated by the evidence to have been at fault.
Something that occurs to me, and I'm just asking for comment, is that naming an individual can perhaps be unfair in the sense that if you name one individual and you don't name half a dozen others, there may not be a very entirely fair attribution of responsibility. However, if you don't mention people, place, time, it's very difficult actually to communicate the idea that you're putting across. I mean, I've listened to what's been said about deficiencies in culture. Culture is not a terribly easy thing to hold on to. And if I were to use the word culture, I might have to go into some detail in trying to explain what I'm talking about. Whereas if I described a particular event, it might be to have a more concrete quality to it. Yes. Do you have any comment?
I would absolutely accept that. I'd give, for example, the prevailing position with the water system at the hospital. At the time the Queen Elizabeth opened its doors to patients in 2015 against the backdrop of the water system having been filled for over a year prior to population of the hospital, that there was no water safety group. The person responsible for water within the organisation didn't even know he was responsible. And to be able to look at that framework and who was responsible and where ultimately blame lies is my submission of key importance to getting to the root of the issue and determining the issues that the inquiry requires to look at. The individual's failures in the role that they were performing at the time is instructive in my submission to ensuring that the same situation doesn't arise again in the future. And in addition to that, it demonstrates to those who have an interest in the inquiry, and those that I represent, the patients and families, have an interest in the transparent identification of those who were involved in and responsible for the decisions that ended up making mistakes that resulted in patients being put at increased risk of infection. But it's very difficult to see any justification for not naming people in those circumstances subject to the observations that your lordship made about fairness. Unless I can assist any further with that heading, I propose to move on to my final and I suspect least appealing paragraph about keeping the inquiry open. And I would simply adopt what's said at section 12 of our closing statement lodged in December last year. And I don't intend to take your lordship to it. I would also refer your lordship to section 14, subsection 1, paragraph A of the Inquiries Act 2005. And it provides that for the purposes of this Act, an inquiry comes to an end on the date after the delivery of the report to the inquiry, on which the chairman notifies the minister that the inquiry has fulfilled its terms of reference. So an inquiry accordingly does not end with the delivery of the report, but rather with the chair's notification to the minister. So what's the issue that I'm seeking to raise here?
Well, just thinking about the mechanical point, if the minister receives what in the face of it is a final report with a caveat or an absence of information from the chair, I suspect a question would then go to the chair as to where exactly are we?
Are we? Well, and where are we is the issue.
Yes.
And this submission is presented following discussions that I've had with colleagues who've been involved in other public inquiries, where a level of frustration has been experienced after the chair's report has been issued, where there have been criticisms made, and where recommendations have been made, but where those who've been criticised and those who would have to act in light of the recommendations have simply stated that they disagree with the findings, with the criticisms and the recommendations. And so what I'd say to your lordship is that comes back to what the purpose of a public inquiry is, and I won't go back to that. On Tuesday, what Mr. Connell said in his submission, I went back on a couple of occasions and noted it in detail. Given everything that has happened since NSS Assure, it should be onwards, we hope that it should be possible to convince even the most doubtful reader that there are mechanisms in place and being operated to ensure that any recommendations that may be made will be carried through. I'm not entirely clear what is meant by that. I suspect that much will depend, obviously, on the nature and extent of any criticism and recommendations that your lordship may make, who they're directed at, and whether it's within any NSS Assure's gift to assist in those circumstances. But again, that's a matter for your lordship's discretion. The concern would be that if your lordship does make criticisms and makes recommendations, what is the scope for calling the party who's the subject of the criticism and recommendation back to explain why it is that they do not accept or disagree with either? And I'm not suggesting that all core participants should be reconvened to come back to deal with matters, but if your lordship is to make criticisms and recommendations, it has to have teeth.
Well, I will consider that. I am aware of discussion in various forums about what is seen as the difficulty. An inquiry makes recommendations, and then it may be the case that nothing much happens.
Or the criticisms and recommendations are simply rejected.
Or rejected. Well, we've heard the word humility.
And Mr.
an
Gray
inquiry process and the power which is given to the chair of an inquiry is circumscribed by the Act. And in broad terms, I appreciate this in very broad terms, an inquiry in the person of the Act uses the word panel, but one might substitute the word chair, is to find facts, listen to as many competing views as are relevant, try to resolve disputes, and then present what's essentially a finding of fact. Now, it's for politicians or the relevant minister to decide what to do with that. And these may very well come to be political questions, which certainly are clearly beyond the competence of the chair of an inquiry. And to put it in familiar terms, I'm not sure that an inquiry chair function, as defined by the Inquiries Act 2005, is that of a policeman. It's more than...
I absolutely accept that.
It's more than an observer.
Yes, no, I do accept that.
Yeah. Anything else?
No, nothing at all, other than to, in closing, extend my personal thanks and those of the core participants that I represent to counsel to the inquiry and their team for their work in this inquiry, to express sincere appreciation for their diligence, fairness, and commitment to uncovering the truth, acknowledging the complexity of the issues that this inquiry has raised, and their role in guiding the process, ensuring a voice for those I represent, and driving future improvements. And also to thank your Lordship for the care that has been demonstrated throughout the whole conduct of this inquiry.
Thank you very much, Mr. Love. Well, that brings the proceedings for today to an end. Tomorrow, I will invite counsel to the inquiry, Mr. McIntosh, to make what will be the final oral presentation in the inquiry procedure. But thank you to counsel for their submissions thus far, and thank you for those who have been attended to pay attention to these submissions. But we'll sit again tomorrow at 10.
Stand.